Arthur Brown maintained his innocence to the end, yet he never acknowledged nor even looked at this.
Years ago, the victims were here to see him die. The family members.
Keith, state prosecutors say Arthur Brown Jr. could have been sentenced to death this month.
To be happy, and yet we're still sad because our loved ones are never going to come back.
The final penalty in the U.S. The final penalty has been a highly controversial issue in the United States for many years. The practice of capital punishment is legal in 27 states, although there have been calls for its abolition in recent years due to concerns about its effectiveness, morality, and potential for wrongful convictions. Supporters of the end penalty argue that it serves as a deterrent to crime and provides a sense of justice for victims and their families. They also point to the severity of some crimes as justification for the ultimate punishment. However, opponents argue that it is immoral, expensive, and prone to errors that can lead to the end of innocent people. One of the main concerns about the end penalty is the potential for wrongful convictions. In the U.S., there have been numerous cases of individuals who were sentenced to demise but later found to be innocent. The use of DNA evidence has helped to exonerate many individuals, but the fact that wrongful convictions can occur has led many to question the reliability of the justice system and the validity of the penalty. Another concern is the morality of the penalty itself. Critics argue that the state-sanctioned slaying of individuals is a violation of human rights and goes against the principles of a just society. Arthur Brown's last days. Brown said the following on the gurney, according to prison officials. "What is occurring here tonight is not justice. It's the slaying of an innocent man for a slaying that occurred in 1992. My co-defendant was executed in 2006, and if I'm innocent, he was innocent, and they destroyed an innocent man, and the state doesn't want the truth to come out. Tonight, Texas will extinguish a second innocent man for a slaying that occurred in 1992. I have no further words."
Keith, state prosecutors say Arthur Brown Jr. could have been sentenced to death this Monday. On the third attempt, we now know Brown's execution date. Had the judge signed their initial execution order that they brought before her, but
after his speech, he was injected with a lethal dose of pentobarbital at 6:20 p.m. and pronounced deceased 17 minutes later. Though Brown was on the row for nearly 30 years, legal claims filed after new penalty public defenders took over the case last year made several dramatic arguments, including that the 52-year-old man was innocent of the slayings. Texas Office of Capital and Forensic Writs asked courts to halt Brown's punishment just weeks before his passing, arguing Houston prosecutors for decades hid evidence pointing to another suspect.
He has been the beneficiary of a judicial system level all the way to the United States Supreme System that bent over backwards at the local, state, and federal.
The attorneys also argued Brown was intellectually disabled to the point where it was unconstitutional to execute him under previous court rulings, and they claimed Brown's trial was tainted by racism, saying a white juror has since said she knew immediately the black defendant was a thug and had no doubt he would destroy again. Arthur Brown Jr. is an innocent and intellectually disabled man incarcerated on Texas's End Row as a result of sloppy police work, prosecutorial suppression of exculpatory evidence, corrupted eyewitness identifications, and false forensic testimony, the public defenders said in their filings. The appeals were unsuccessful in state and federal courts, with judges largely saying the claims did not clear the high bar to consider appeals this late. Harris County prosecutors denied they shielded evidence, saying attorneys could have found a witness interview pointing to another suspect earlier. The district attorney's office also disputed that Brown qualified as intellectually disabled and argued the racial bias claim could have been raised earlier in the decades since Brown was sentenced. Arthur Brown's case. Arthur Brown and two other men were convicted in the 1992 slayings of Jose Guadalupe Tovar, Jessica Quinones, Audrey Brown, and Frank Farias. The four victims were each tied up in Tovar's Houston home and shot in the back of the head. Tovar and his wife Rachel were known drug dealers who supplied cocaine and marijuana to Brown and the other men, according to court documents. Rachel Tovar and Nicholas Cortez were also shot in the head but survived.
Arthur Brown maintained his innocence to the end, yet he never acknowledged nor even looked at this.
He did sign, but we have to wait until next year. And most of the time, to be happy, and yet we're still sad because our loved ones aren't ever going to come back. He'll end and it'll continue like it has for 30 years.
Of these murders, he was executed in 2006. A third man, Antonia Dunson, was sentenced to life in
Our loved ones aren't ever going to come back. But now he's went to join them after he left.
The slayings and Brown's subsequent trial were sensational, with allegations of police and prosecutorial coercion of witnesses, shocking recantations on the stand, and Brown's sister jailed in contempt and later charged with perjury. 3 of Brown's sisters testified for the state, placing Brown at one of their houses in Houston the night of the slayings after the drug buy, according to court documents. 2 said he offered to pay them to take his van filled with drugs back to where he lived in Alabama while he flew home the next day. After being held in contempt for initially refusing to testify, despite having been granted immunity, one sister, Carolyn Momo, testified that Brown had told her he had shot 6 Mexicans. On cross-examination, Momo said her earlier statement was false, and she and the other sister said on the stand that they testified because police had threatened to take their kids away if they did not. She was later prosecuted on a perjury charge for changing her testimony. 2 other men, Marion Dudley and Antonio Dunson, were also convicted of the capital offense in the case. Dudley, who also maintained his innocence until his end, was ended in 2006. Dunson is serving a life sentence. Renewed doubt. Defense attorneys always considered the case against Brown flimsy at best. Aside from the recanted testimony, prosecutors largely relied on eyewitness accounts by the slaying's 2 survivors, both of whom had questionable recall after being shot in the head. At trial, Rachel Tovar and Cortez both identified Brown as their assailant, but Tovar gave conflicting information to police in the hospital, and Cortez had earlier failed to pick Brown out of a photo lineup, according to court filings. In Dunson's subsequent trial, Cortez again failed to identify Brown from photos. The physical evidence tied to the incidents, guns believed to be tied to Brown and believed to have fired the fatal rounds, were recovered elsewhere, including on another man after he was destroyed in a similar attempted robbery at a drug dealer's house in Alabama.
Quite frankly, that was not her job. Her job, August of this year. Judge Cornelio disagreed with us. She also disagreed with us that he could have been executed in November. We believe was to have signed the first execution order that we for all.
That man, Terrell Hill, was the focus of the defense's theory at trial, pinning him as the likely shooter. The science used to connect the guns to the bullets found at the scene were later discredited on appeals, but the Texas Court of Criminal Appeals still upheld Brown's sentence. The judges ruled the jury still likely would have convicted Brown without the ballistic evidence. But in a police interview kept out of trial and undisclosed to Brown's attorneys until this year, the son of Rachel Tovar said his mother used a nickname for Hill when describing her assailants to police in the hospital. She told police in one interview she heard the nicknames Red and Squirt being used in the incident, and that her son would know them from answering the door. This month, Brown's attorney said the evidence should have elicited a renewed look at his innocence claim. Mr. Brown presents to this court long-suppressed information by the Harris County District Attorney's Office pointing to Marcus Terrell Hill, a Tuscaloosa drug dealer who was shot and destroyed trying to rob a crack house in Alabama while in possession of the alleged slaying weapon in this case, as the party responsible for the slayings for which Mr. Brown and his co-defendants were wrongly convicted. Public defenders wrote in appeals in the last week of Brown's life.
He denied killing these 4 people in that home on Brownstone Lane. Today was not a celebration. It was not a happy day, a day she did not want to be here for. But she said, remembering Jessica Quinones, she was the 19-year-old pregnant woman who was killed. One of the
Harris County District Attorney Kim Ogg's office said the interview could have been acquired by appellate attorneys years ago, when lawyers conducted public information reviews of the state files. It's unclear if the videotape was in the case file at the time. The state also said Fariah's testimony would have added little weight anyway, as it was hearsay. Plus, prosecutors said Hill had an alibi. His cousin had said, backed up by rental car records, they arrived in Houston the day before the slayings, but couldn't find a hotel room so they drove back to Alabama, according to court records. Ogg's office stood behind Brown's conviction, noting that Brown's friends referred to him as Squirt, and prosecutors credited Rachel Tovar and Cortez's visual identifications of Brown. The state also continued to point to Momo's quickly recanted testimony, saying Brown told her he shot Mexicans and that her gun had gone missing. After Brown's passing, Ogg said in a statement that despite an eyewitness identification, Brown still refused to take responsibility and tried to escape any kind of accountability. Brown's disability. Aside from Brown's innocence claim, his attorneys also attempted to halt his punishment on claims that he was intellectually disabled. Since 2002, the U.S. Supreme Court has barred the final punishment of those with an intellectual disability, deeming it violates the Eighth Amendment's ban against cruel and unusual punishment. In Brown's case, attorneys provided evidence that Brown had been in special education classes since he was a young child and was deemed educable mentally retarded in elementary school. In third grade, his IQ was measured at 70, generally considered within the range of intellectual disability. Brown's attorneys also noted he was typically thought of as slow throughout his life, and his friends and family learned to talk to him in simple language. Prosecutors countered that Brown was not intellectually disabled, but instead had a learning disability. They noted that his IQ scores in middle school bumped up to the high 80s, with the school psychologist suggesting he be moved from the class for the mentally retarded to a class for students with learning disabilities. In his final appeal, Brown's attorneys hoped the disability claim would prompt the nation's High Court to halt his punishment. For years, the High Court has knocked the Texas Court of Criminal Appeals' methods for determining such disabilities, sending one case back repeatedly. The justices denied Brown's final appeal on the day of his passing. That's all for today's video. See you all next time.